monitoring issues surrounding his communication with the EC chairperson, the returning officer in the presidential elections, and circumstances leading to them, he and his colleague, Dr. Pesa White, leaving the Electoral Commission's office to have an interaction with the petitioner, John Mahama. We've just had Mr. Mahama is the second respondent in this case. Mr. Akufo-Addo's lead lawyer, Koto Ampao, also cross-examining the witness. The court is on recess because even before we got to this point, the bench had disclosed that they were going to take a break so that the witness could also take a break, and they would continue with the cross-examination of Rojo Mettle-Nunoo. So the second respondent's lawyer is not done cross-examining the witness for today. The third from the petitioner's side, Rojo Mettle-Nunoo, court is on recess to return with this cross-examination. We'll be speaking to our court correspondent, Joseph Akable. Lawyer Samson Ladia Yenini will also help us with what has happened so far in the court processes. This, of course, is JoyNews as our election petition update in association with Petrosol, Coa Mixture, and also DBS Roofing. Please stay with us.
Imagine a family without a home. Imagine a song without a voice. Imagine a church without prayers. Imagine a government without citizens. Imagine democracy without journalists. Imagine a world without the media. Life is full of issues and stories about people, communities, and governments. Stories that have to be told by well-trained journalists. That's why you can't imagine news without JoyNews.
Hello there, welcome to News Today. Now coming up in the next hour, CEO of National Ambulance Service reveals robbers who shot and killed an ambulance driver and robbed a pregnant woman in labor, also sexually assaulted a paramedic who was with the team. More, as he says, the incident has dampened the service, plus family of the officer demands expedition in the investigations leading into the shooting. Also, as Ghana's COVID-19 death toll hits 464, work on in-house testing facility at the Greater Accra Regional Hospital completed to aid in the fight against the virus. And also, third witness of the John Mahama in the election petition case has been cross-examined. While the process is still continuing, court is on recess, and we will do some analysis and reactions on what has transpired so far. In business, Cocoa Board in advanced talks with banks to draw down rest of syndicated loan to pay license buying companies. Details shortly. Well, we'll start with what has transpired in courts in the ongoing election 2020 petition. Our court correspondent Joseph Akable has joined us. Joseph, we've seen the third witness for John Mahama, Roger Mettle-Nunoo, testifying in court today, but it's been quite heated. Tell us what has gone on so far.
And so, yes, he has so far been cross-examined by Justin Amenuba, who is lawyer for the Electoral Commission. And the cross-examination has mainly focused on the issues relating to how he certified some of the regional results, despite having concerns and those that he could not certify as well. And so Mr. Mettle-Nunoo, in the course of cross-examination, did admit to the fact that he certified a good number of the results, and the ones that he could not certify, he did indicate that to the court. Specifically, there were 3 regions that he did not certify. And he explains that even the ones that he certified, so in terms of the ones he didn't certify, there was the northern region, the Greater Accra region, and the Blue East. And the other ones that he certified, some of them he said he had concerns about it. And specifically, the concern was that he did not have the full complement of the constituency result that made up the region. But nonetheless, he certified those ones as well. Then the concern was raised about when he left the strong room and whether at the time he was leaving the strong room, he had seen all the results that had come in from all the regions. And he did indicate that, yes, he had seen all those results, but some of them had problems, i.e., in his own words, they were not accurate reflections of the votes that had taken place. It was also pointed out to him that in terms of the IPAC arrangement, each party was permitted to have 4 representatives, but the NDC opted to have 2. He did indicate that, yes, that was the case. But even in terms of when they decided to go and consult with their presidential candidates, even if they had 4 people there, the role and the things that had happened in the strong group was such that he knew people could not come in and perform the role that they were performing prior to leaving the strong room. And so those were the highlights of the cross-examination that took place by way of Justin Amenubo and Roger Mettle-Nunoo.
And just before the court went on recess, with the explanation that the witness needed to take a little break, there was also Akoto Ampao questioning the witness. But it hasn't gone all smooth with this.
Yes, there have been a few interjections here and there, including the panel itself, coming in some instances to point out that some of the questions were matters of law, like a question about the fact that whether they certify the results or not, whether the EC chair could proceed to do the computation and have a declaration done. The question about when they decided to leave and go over to consult with their presidential candidate, that did not bar the EC chairperson from continuing with the process of the results. A question was put to him about a claim in his witness statement that there was a difference of 1,700 votes between the results that were declared by the Electoral Commission as compared to what was put on the EC's website. And in that particular question, the point was made to him that the 1,700 votes were not significant to affect the results or the outcome of the elections. And his response was to the effect that little drops of water make a mighty ocean. And so, as far as he's concerned, those 1,700 votes were still significant. And so that was also a bit of what has transpired by way of Mr. Akoto Ampao's cross-examination. A point was also made about the fact that there are certain things that he had talked about that were not part of the issues that Dr. Kwesa White had testified to. He was the other representative in the EC strong room. And at that point, the panel came in to point out that, yes, there are 2 individuals there, and if you ask 2 individuals to give a report on any event, it's not necessarily the case that the matters they will report on will be the same.
And Joseph, we're not done with the cross-examination because after the break, Akoto Ampao will continue with his questioning.
That is so, and we understand that it will continue along the lines that's already commenced to make the points to Mr. Mettle-Nunoo that he left the AC headquarters on his own, and to again put across the fact that the respondents believe that the fact that he left it did not affect the outcome of the results and could not have stopped the process that was undertaken by the Electoral Commission. And so we understand it's a 30-minute break as announced by the Chief Justice, Enini Amwa, who is the presiding judge over this particular matter along with the other justices. And so after 30 minutes, we expect Mr. Akoto Ampao to resume the cross-examination.
Joseph, 30 minutes, it's a lot of time for you to grab some lunch. We will continue with you later on when the court resumes. But let's speak to Samson Ladi-Ayenini. Let's get some legal clarification of the processes so far. Samson joins us via Zoom. Thank you very much, Samson. Good afternoon. Thank you for your time here on News Today. Lawyer for the second respondent was interrupted in his questioning on a number of occasions. The reason was those issues were matters of law. Can you explain what can a witness answer and what can he not answer?
Okay, so some of the things, the answers that the witness is not to deal with are questions of law. Because the witnesses are not lawyers, and therefore the rules don't allow that they be made to answer questions of law. Of course, it is the reason every party most likely often have lawyers. So when it comes to matters of law, we, the lawyers, are able to determine how to interpret the law and so on and so forth, and not a lay person whose interpretation would actually mean nothing to the courts, particularly if it is completely wrong, you, the lawyer, cannot seek to capitalize on their wrong interpretation of the law for any purpose. So a court should not waste its time by allowing a lawyer to exact answers on questions of law. It is also part of the reason we have what we call addresses. Elsewhere, they call it closing arguments. In the addresses, we will take the witness, their testimony, and then we will seek to find out where we think they were being untruthful, where we think they contradicted each other or contradicted themselves. And then in the address, we'll point out the effects of the contradictions, or where we can establish by the address that the witness has told untruth. So they could say something today and tomorrow they will turn 360 and deny it, and so on and so forth. And sometimes they may deny something that they had already said, and then we will confront them with it, either through the cross-examination, or you watch them to tell what you know they have told a lie about, and then in your address you pick that issue and then match it with the lie, and then point out that it is a lie.
And some saying, is there a prescribed way of answering questions when you're in the witness box?
Right. So in practice, I asked your question, your name is Mamavi Owusu-Abuaji. Is that not so? You answer, yes, that's my name. If you must explain, then you would say, yes, that's my name. But at the time the issue happened, I was not married, so I didn't carry Owusu-Abuaji. I was so and so. So you are allowed to answer, either give a yes or a no, and then proceed to explain if you have something to add. So in practice, that's how we go about it, so that nobody wastes anybody's time in the courtroom.
When we're witnessing, and indeed what we have witnessed with the witnesses giving their testimonies, it hasn't been exactly straightforward. We've seen a lot of explanations. Is it because this is the Supreme Court, so the rules don't necessarily apply here?
At times, judges will allow witnesses to go ahead how they want to approach it. But again, that's why the lawyers are there. So a lawyer can point out to a judge that the manner in which the witness is answering is not what is the tradition, and it's not what is done in court. So they should be reminded to do it. Again, the system appreciates that witnesses are not like professional witnesses in the courtroom. So they may not know how things are done. So they may have been prepared by their lawyers and told that this is how to answer. If a lawyer says, I put it to you, your response could be, I agree, I do not agree. You do not need to say yes, or you do not need to say no. If a lawyer puts to you a question which solicits your opinion, you are at liberty to proffer the opinion or not to proffer the opinion. You are not at liberty to say yes or no. It's a question of opinion, and that you are seeking. And you are not exactly expected to be seeking opinions in the courtroom, at least on matters that do not directly relate to the case at hand. So sometimes the system takes it slowly to get a witness to warm up and to get to appreciate, particularly if it's a witness that may be cross-examined for a number of days. The first day, it's okay that they may forget themselves. They may even respond to a lawyer directly rather than coming to the awareness that they are responding to the questions to the court, and they may want to do what Rojo did, which is not allowed. A lawyer asks a question and you ask a question back. You don't do that. You answer the question to the best of your ability. If you simply want to say a no, just say no and move on, rather than ask a question back. You don't do that. He was seeking to question his credibility. So you realize that he brought in his character, trying to question his character is allowed, because when you put a witness in the box and you're on the opposing side cross-examining them, you want to discredit that witness. You want to show that they are not credible by virtue of how they are giving answers, by virtue of certain things they have done that before. And you see, he had information, the lawyer had information about this witness being outside of a hospital or being in town on a particular day. And so we always say in cross-examination, you don't ask questions whose answers you do not know. So many of the times, we know the answer before we ask you the question. But we need you to confirm or deny. If you will not confirm and if you will not deny, then we will confront you with it by putting it to you in the witness box.
And what kind of rights has a witness got in defending himself, especially when the lawyer makes a remark that is not necessarily a question? And we saw that with Justin Amenuvo, the very last statement that he made. And we saw Roger Mettle-Nunoo trying to ask permission from the court to respond. There was nothing. How do you rebut that?
Okay, so if he had decided to go ahead and make a comment, a side comment, he would have done it right away. But I think he got to a point he discovered that he needed to seek permission of the court to do certain things. You see, we are lawyers. We are also not perfect. And there are times that everybody else may get emotional about what they do, even though, because this is our practice, we do it every day. We are not supposed to attach emotions to them. It's work. We do it and move on. It's hard to lose. It's so good to win, but it's a certain way. You are not supposed to be emotional about the whole thing. And so if a lawyer, attaches emotion to it, the point is that the side comment that the lawyer makes is not part of the court's record, because it is not a question to the witness. It's not part of the court's record. If a lawyer is making commentary whilst asking questions, it's not part of the record. So when the case is over, as in when the testimony time is over, and you ask for a copy of the court's record, you will find that those comments will not be in the record. Okay. So as far as the court is concerned, those are not important at all.
But are those not comments that could also influence the bench?
Because they are not part of the record, they are not supposed to be there. They don't matter. When they are going to write their judgments, they will be looking at the body of the testimony record, and that comment will not be there. Sometimes it will be a long time. They may even have forgotten about it. They don't remember it. And they are trained to discount what is not important, because it cannot actually come into the judgment. But as you say, judges are human beings like us. We all have emotions and so on and so forth. And so there can be a psychological battle because of a particular commentary. Now, I will admit that this witness, from the very start, I was a bit uncomfortable with the manner in which the lawyer began to cross-examine him. When you are cross-examining a witness, even though the witness has so to speak, an adverse position to your position in the cross-examination. His job is to testify to help the case of the party that he is testifying for. And your job is to ensure that that witness, or that testimony does not stick. But when a witness doesn't begin by shouting, by evading your questions, or by being unnecessarily putting up a conduct that is not necessary, you don't give back the way we saw. From what we saw, I can say every lawyer has their style. Every lawyer obviously have their style, but I would say that to begin on a note of, treating the witness as if it is a witness that has been declared as a hostile witness. There are witnesses that the court will be asked to declare them as hostile. Then once the court allows room that they have been declared as hostile, then their treatment becomes different. But normally these witnesses will be witnesses that would have been brought in to speak for you, but they tend to want to turn against you, and then you turn them to a hostile witness, and then you ask them in a certain fashion. I think the initial aggression, the shouting, and the side commentary of interfering and seeking to shut the witness down and so on and so forth were not necessary.
Just finally, something. What is the position of the law when witnesses hearing each other's testimonies in courts?
Okay, so it's a basic standard, rule. It is the reason when you enter the courtroom, before a witness takes the stand, the announcement the court makes is, everyone in this courtroom who, except you are a party, if you are in to testify and it's not yet time for you to testify, you must be out of sight and out of hearing. Out of sight and out of hearing. Mama V, the challenge here is that this is being broadcast live on television, on radio. So that principle may not work. So it will be on the good faith of the lawyers and that witness to tell the witness that, yes, even though you are not in the courtroom and you have access to what is going to go on by other witnesses, please don't listen to it. But the truth again is that when a witness has testified and other witnesses have been out of sight and out of hearing, it is the lawyer that prepares the next witness to come. So the lawyer would definitely prepare the witness, let them know that, this has gone on, you blah, and all of those things, even though we are not allowed in law to do what is known as coaching. We are not allowed to coach a witness as to what they have to say. We are supposed to guide them and let them understand the strategy of our case and what our end game is. So they keep that in mind all the time. You can do some of that, but your witness may crumble in the witness box. In the witness box, anything is possible.
Yeah.
And sometimes let me say this, sometimes there are things we do and we do it on purpose. We put you in the box and we try to provoke you a bit, because it is when you are angry that we can get you to mess up.
So in this case where it was established, because the witness did accept that he had been following the procedures, what impression does that make on the court?
I would say that we should stay away from pronouncing on it, because the court will take a view of it and we will hear what the decision will be. If we attempted that, we might be crossing the bar, we might be crossing the line. But like I said, the standard is that normally, and you would have seen this many times, witnessing a court proceeding, that they will say, if you have to testify in this issue, in this case, be out of sight and out of hearing.
Okay. All right. Samson?
Because we clearly must avoid a situation where you will work together to tell a lie and let it be coherent.
Okay. Samson, you're going to go out of sight, but definitely not out of hearing, because we're going to connect with you again later on when the court resumes. So we'll move away to some other stories now. Chief Executive Officer of the National Ambulance Service, Professor Ahmed Zakaria, says armed robbers who shot and killed an ambulance driver did not only rob a pregnant woman in labor, but also sexually assaulted a paramedic who was with the team. He says the morale of the National Ambulance Service has been dampened by the horrific incident.
Honestly speaking, we are all at a loss, and up to now we've not recovered, because nobody will have thought that an ambulance carrying a sick patient will be attacked. One will have assumed that maybe they mistook it maybe for a police vehicle, but for the armed robbers to get close, identify it as an ambulance, shoot the driver, and still shoot the vehicle, force the patient compartment open, see a patient lying on a stretcher, being attended to by a paramedic, and still go ahead to rob them and manhandle them, is something that definitely we are yet to come to terms with. We never will have believed that such a thing can happen. Initially, people were trying to rationalize that perhaps they mistook the vehicle as a police vehicle, but subsequent events showed that that wasn't the case, because they really got closer, they saw it was an ambulance, and after they shot the driver, who was himself a paramedic anyway, they still forced themselves into the patient compartment. And after everything, they forced the poor lady to go and switch off the engine because they felt that the siren and the beacon light was drawing attention. So obviously, it's something that we have to condemn in no uncertain terms.
Actually forced one of the workers to go and put off.
Absolutely. So what happened was that after they shot the vehicle, the driver definitely was injured, so he could not move. So now the patient, the paramedic, they were in the patient compartment, and normally it's locked. So they had to force it open, shoot the vehicle, force it open, enter the vehicle, rob the poor girl of her telephone with whatever was on her, fondle her breast, force her into the driver compartment to switch the engine off so that the beacon light will be off so that it will not draw attention. Obviously, it was really tragic and very pathetic, and it's not something we can even rationalize and say that perhaps they thought it was a police vehicle.
There's even an element of sexual assault, there.
Definitely. So the lady is really traumatized.
Who did they assault? Is it
the paramedic? There were two of them. The driver who...
Well, we'll definitely bring you a lot more on this. We have to take you back to the Supreme Court to continue with the cross-examination of Roger Mettle-Nunoo.
My Lord, I was misled by your calling me, Mr. Nunu, please turn your camera on. Everything is on. Now, Mr. Mettle-Nunoo, I'm putting it to you that the matter you said you were going to inform the petitioner in respect of was a matter that you could have discussed with him on the phone, especially at the critical time of collation at the National Coalition Center. I'm putting it to you.
Is it a statement or a question?
I'm putting it to you.
That is not correct.
I'm furthermore putting it to you that you had a working phone with you at the time.
The question again.
I'm putting it to you that you had a functioning phone with you at the time you were leaving the National Coalition Center.
You said worked with me.
A functioning mobile phone.
Yes, I had an iPhone that was functioning.
Yes. And indeed, it was the same phone that you allege you used in an attempt to reach the EC chair.
At various times, yes. In some instances, I got her, and at other times, her phone was off.
Now, I'm putting it to you that nowhere in your witness statement do you demonstrate with numbers how your alleged errors in the figures impacted in any material way.
It has more to do with a trend of anomalies, several anomalies. And we were seeking a forum for a proper presentation of those issues.
Okay.
We were seeking a forum for the proper presentation of those issues.
Well,
For example,
well said.
Can I give an example?
You can't give examples here. Now,
For an example,
now I'm referring.
Respectfully, why can he not give an example?
Because I'm referring to his witness statement.
His answer. He's cross-examining. The witness is saying, I want to give an example to explain my answer. Why is that disallowed?
Mr. Mettle-Nunoo, you can go ahead with your examples.
my lord, for example, the Eastern Region 2 summary sheets that were presented, the total number of valid votes as recorded on those 2 sheets was the same. But in one of them, Nana Addo had much higher figures being attributed to him. The petitioner's votes were reduced, and similarly, all the other presidential candidates also had their figures reduced. But the totals of that second summary sheet was the same. That was the specific fraud. That was a specific manipulation. That was the specific anomalies that we're referring to. How is it possible that the same regional office can submit 2 separate results? On the face of it, the total votes cast is the same, but then the vote attributed to each of the candidates was taken. And in one of them, our candidate was not present to sign or to vet or verify. And then you are tendering both of them. Which of them is the original and which of them is the genuine result? Which of them? In another instance, you have a whole constituency, the results not recorded, and yet the summary sheet has been submitted by the EC regional representative of the returning officer. And if I sign that in error, and I come back and tell you that I have observed that that is an error, Why can you not address it? Because the regional summary must have 100% of all the constituencies' results as tabulated, and not that you have one omitted. It cannot stand as a summary. And in the same instance of examples, I observed several of those summary sheets having errors in figures and words which affected the summary of the total.
Yes. So,
several of them.
So my point here is that you have not given this court the details of the figure as to affect the outcome of the elections. That's the point I'm making. I'm putting it to you.
My Lord, the question is muffled.
Have you not given
it? The question is muffled by him. I can't hear the question properly.
I'm saying, putting it to you, that you have not presented to this court the details of the figures that have a material effect on the overall outcome of the 2020 presidential elections. That's what I'm putting to you. And it's on the
lords
of the record.
My lords, I have alluded to anomalies that, if tabulated, would add up to the figures. I have raised in my statement of 32 points that in specific anomalies that I noted, this was the case. How is it that that does not refer to figures? I may not have given you specific figures, but I've given you instances in Ashanti, in Eastern region, in Bono East, in Northern region, in Greater Accra, in Eastern region, where these things have been seen and noted. It's a reference to the, mathematical infractions. It's a reference. And if the court was please, you've asked the question.
Mr. Mettle-Nunoo.
The candidates you represent, they benefited hugely from these anomalies that I'm referring to, benefited, and that resulted in the board result that was declared.
Mr. Mettle-Nunoo, see, I don't know, the whole your cross-examination is on I put it to you, I put it to you, I put it to you. Now I'm wondering whether that's all that lawyers do in a courtroom. I put it to you, I put it to you, I put it to you.
My lords.
Because this is cross-examination.
Yes, my lords.
And what I'm expecting is witness control.
Yes, my lord.
And because there's no witness control, that's why the witness is going on a tangent. And I don't know how many more I put it to use you have before we close this.
My lords, the record of his evidence is before the court. If I put it to him and he's saying something else, that is a journey in futility.
But why not exercise witness control? There's a way in cross-examination to control the witness. So to agree with what you want the witness rather than to leave the witness and to go on a tangent. Because we can continue with this for the next... So
Mr. Mettle-Nunoo, you see, in the Eastern region, you will see from the record that a whole constituency's vote, Ayensua-Nu, was omitted in the first summary sheet of the region. So what happens in the second summary sheet was...
My lords, respectfully, the counsel cannot give evidence. Counsel cannot give evidence. What happened in the second sheet, that's evidence. It cannot be allowed as a question.
See, Mr. Mettle-Nunoo, the first witness of the petitioner appeared before this court and admitted to the correctness of the second summary sheet for Eastern region.
My lords, that is not an accurate account of that first witness's cross-examination. In any case, that witness...
Please.
No. Mr. Mettle-Nunoo, I am saying that you should take a look at the 2 summary sheets from Eastern Region.
Which summary sheet are you referring to?
The Eastern Region summary sheets.
You must refer to a specific time of transmission because that will tell me which one. Is it the summary sheet? Is it a summary sheet?
Please listen to the
that was collated at 9:39 a.m. Is that the summary sheet of 9:39 a.m.?
Mr. Mettle-Nunoo, you said there were 2 summary sheets from the Eastern Region. The lawyer is asking you a very simple question. He says, look at the 2 summary sheets from Eastern Region. You look at it, and maybe the question will follow. You don't go off like we are going. You not even finish today the way you want to over-elaborate on some of these simple matters. He said, just look at the 2 summary sheets from Eastern Region. Then you leave him to follow up with his question. That is all. If it is not before you,
very well.
If it is before you,
very well, my lord. Very well, my lord.
Now, you notice that in the first summary sheet, which you signed, you have as the total valid votes 1,196,751 as the total valid votes.
That is not what I have in front of me. The total valid votes here is 1,236,940.
Yeah. So just pay attention. You see, on the second but last column, you see 1,196,751. Is that not so?
I am not sure I am seeing what you are talking about.
I'm talking about the second but last column of the columns on that summary sheet. Second but last column.
So what is the My lord, I cannot see the specific reference to which you are. I cannot see it.
Where you have total valid votes. Second but last column. Where you have total valid votes.
And also, I think it will help all of us if we know exactly what document is being referred to, because I think we really.
Yes.
And if we.
Witness may see where we are going.
2 are attached to Mr. Seyedun Kettieh's witness statement.
He may not have.
Yes.
But there are 2 different transmission times.
Yes.
So mention which one you are referring to. So the witness will know.
I'm referring to my Lord, it's not this 8:56 a.m. p.m. Sorry, it's 8:56 p.m. on the 8th of December.
The documents, yes, they're referring to Asiedu. This is in reference to Asiedu Kettieh's witness statement. And in reference to that witness statement, to the extent that it relates to Eastern Region, I do not see the 8-something p.m. Yeah.
Mr. Akotampa. One came at 6:40 p.m.
Exactly.
And one at 9:39.
Exactly. Exactly. That is what we also have.
Yeah.
Something.
No.
That's what he said. Maybe he can show us the 8 p.m. one so that we see whether it fits with anything that we have.
My lords, that's the first document.
Is Akotampa?
Yes, my lady.
Mr. Sidon pretended to headed Eastern Region. Both were signed by the Regional Coalition Officer Faith and Mejake. Is that what you have?
Yes, my lords. There is the one with the blue stamp.
That's 9:39.
That's the 9:31.
Yeah.
9:39
a.m.
And then there's an earlier one.
No. We don't have an earlier one. We have a later one, which is 6:40 p.m.
The 8th on it is the date.
Yes.
8/12/2020 is a date.
Yes. Which is 6:40 a.m.
Yes.
40 p.m.
It's
p.m.
Put on your spectacles, Mr. Akotampa.
My lady, I think that
I was only teasing. It's
something different from what we are speaking to.
No, my lord, we do not. Now, our point is, if one were to add yes, my lord, if one were to add all the figures attributed to the different candidates, on the one with the blue mark,
That's 9:39.
yes. It does not have your signature. You arrive at 1,236,440. 940, sorry. Is that correct? Is that correct? Yes. My lords, because there is an error of addition when you go through the...
My lords, that is correct.
Yes.
you will get 1,236,940.
Very well. Now, if you take the summary sheet that you signed and you do the addition of the actual figures, you will see that it is less 40,189 of the 1,236,940. In other words, if you add all the figures, the votes that the candidates obtain, you will get a total which is less of 1,236,940.
I think you're overloading your question. You should break it down.
Okay. So I'm putting it to you that if you add all the figures on the sheet that you signed, you get a total of 1,196,751. That's the actual total you get.
My Lord, if I may.
Go ahead.
If you look at the totals without looking at the attributed figures to each candidate, you'll be making a big mistake.
Asking you the figure that you get. Please, when you respond to it, then you can give your commentary.
That is correct. That is correct. Can I go on now with the explanation?
Hold on. So
on the 9:39 a.m. figure, you find that they gave to Nana Addo 752,061, and on another sheet he gets 729,146. But the total number of votes cast is the same. The total number of votes cast in the two documents in contention are the same.
So just take your time. So I'm saying
the total number of votes cast is the same.
Yes, hold on. I'm saying that the difference between the 1,196,751 and the 1,236,940 is 40,189. That's the difference.
That is the case.
Yes. And that figure of votes is exactly the total valid votes cast in an Asensuano, Ahinsiano.
Mr. Akutuamba.
Yes.
You did this with the Mr. Asedun Kitia.
Yes.
So what are you trying to do now? Get something different or to corroborate him or what?
My Lord, that's why I put it to him that this was, as Asedun Kitia actually admitted, that there was an error. Very well.
It's not the admission.
Yeah, and to add up, Mr. Asedun Ketia, it was he who attached these documents to his witness statement.
Yes.
You have cross-examined him on it. He has admitted the difference. Mr. Mettle-Nunoo has not attached any such thing to his witness statement. Right. Why do you cross-examine him on somebody else's documents?
No, my Lord, he referred to it in his response. That's why. So So, you see, I am suggesting to you that nowhere in your witness statement do you show how your alleged lack of transparency and consultation had an impact on the final outcome of the elections. You have not shown it.
Well, that is correct. But I made an aversion that there were anomalies, that there were serious anomalies.
Now, that will be all for the witness.
No re-examination.
There will be some few questions from the bench.
Good. Mr. Mettle-Nunoo, you have admitted in this court that you left at a point in time to go and see the petitioner. Is that so?
That is correct, my lord.
You have also admitted that you signed most of the summary sheets, the original summary sheets, 13 of them, out of 16.
That is correct.
Good. Now, did you sign these summary sheets before you left to see the petitioner?
Yes, I did sign the 13th before going to see the petitioner.
Okay, thank you. Can the witness be discharged, Your Lordship?
By court, PW3 is discharged as a witness.
Most grateful. That is the end of our case.
Okay. By court, the case for the petitioner is closed. Yes. Yes, Mr. Mettle-Nunoo.
My lords, with respect, it's our submission that in view of the evidence led by the witnesses of the petitioner and our cross-examination so far, speaking for the first respondent, I'm of the view that there's sufficient evidence before the court for this petition to be determined. And therefore, my lords, yes, my lord, I was saying that giving the evidence of the petitioner's witnesses and the cross-examination so far, of those witnesses, my lords, speaking for Speaking for the first respondent. Yes, my lords, it is the first respondent's case that we do not wish to lead any further evidence, and therefore we are praying that this matter proceeds under Order 36, Rule 43, and CI 87, Rule 3E5. And we hereby, on that basis, close our case. That is so. That is so.
Mr. Menuvo,
yes, my lord.
What then happens to your witness statement?
Well, my lords, under CI,
you file a witness statement.
Yes, my lords.
And the witness statement is supposed to be subjected. It's going to stand as your evidence in chief.
Yes, my lords.
And therefore, it's supposed to be subjected.
Yes.
To cross-examination.
Yes. My lords, under CI 87 Rule 3E5, where if a party who has served a witness statement does not call the witness to give evidence at the trial or put a witness statement in as hearsay evidence, any other party may put that witness statement in as hearsay evidence. So, my lords, we are saying that we are not calling any further witness. If the court decides to treat our witness statement as hearsay evidence, well, the court is entitled to, but we are not leading any further evidence. We are not calling evidence.
Did the rules say the court can treat it as hearsay? So any party?
No, the party, a party, not the court.
So
sorry.
Not the court. Yeah.
The other side can treat it as such. Thank you.
My lords, respectfully, we need to understand the nature of what is being put forward clearly.
In a nutshell, it is a submission that giving the evidence from the petitioner to a petitioner's witnesses and the cross-examination so far. Speaking for the first respondent, we do not wish to lead any evidence. We submit that we are not calling any evidence and close our case. Then he refers to Order 36.
Order. You refer to Order 36. Yes, sir. Order 36.
My lords, Order 36 Rule 43, with your kind permission, if I may read. Where the defendant elects of CI 47, my lords.
Yeah.
Where the defendant elects not to adduce evidence, then whether or not the defendant has in the course of cross-examination of a witness for the plaintiff or otherwise put in a document, the plaintiff may, after the evidence on behalf of the plaintiff has been given, close the plaintiff's case, and the defendant may then state the case for the defendant.
Respectfully.
Yes, my lord, CI 87 on what will happen to the witness statement if you choose not to enter the box, my lords. Rule 3, that's sub rule 3E sub 5.
The alternative is to have it.
It is our respectful submission that counsel for the first respondent does not have it open to him to take the course that he just proposed to this court. Order 36. Rule 4.3 that he refers to specifically says where the defendant elects not to adduce evidence. In these proceedings, the defendant has put in a witness statement. So, my Lord, I'm sorry.
Yet evidence. It is just a statement.
My Lord, what this provision says, where they elect not to adduce evidence. And what I'm saying is that the election that they made to submit the witness statement to the court is a clear indication that they made an election to the contrary. Because, my lords, in these proceedings, at the point of case management, your lordships basically asked questions from all the parties as regards witnesses being called. And it is at the point of case management where such an election is notified to the court. At that point, they elected to submit a witness statement. Now, that witness statement is not yet in evidence. That is true. But this is referring to an election. The point of election came at the point of the case management. And we are respectfully submitting that this witness cannot run away from cross-examination when they have elected. My Lord, when they have elected, that is the point. They have elected to
the language, please.
Oh, my Lord,
maybe you can
my Lord,
but run away.
My Lord,
it is being a telecast, and people may
very well.
interpret it.
I will adopt your words. So if your lordship,
yeah, he's evading.
My lords, I will totally adopt your lordship. I will totally.
Yeah, please, you have the opportunity to. Yes.
Yes. Assuming we were not dealing with witness statements.
I'm sorry.
Assuming we were not dealing with witness statements, and we were giving oral viva voce evidence, when would you say that a party has elected not to give evidence? Assuming we were not using witness statements.
At the case management stage. If the party at the case management, my Lord, at the case management stage, the party may, no, otherwise the case management stage is meaningless.
No. If a party is called upon to testify, and then he tells the court, I do not intend to testify, that is when we will say that the party is not willing to adduce evidence.
My Lord, respectfully, that is not the situation under the rules as amended to provide for case management.
Order 36 is proceedings at trial. So we have moved into trial stage. Order 36 deals with proceedings at trial.
I appreciate that, and the point I'm making is that Order 36 is premised on where the defendant elects not to adduce evidence. So, my lords, what I'm saying respectfully is that in the context, Order CI 47 obviously precedes CI 87. And in the context of CI 87 and the provisions for case management, the case management context is a context in which, for the purpose of a trial, the judge asks the parties how they are going to proceed. That's what I understand case management. Your lordships have had many occasions to point out the significance of the case management process. And my respectful submission is that it is in that case management process where, one, the party gives an indication to the court that I intend to call these witnesses. Now, if the party gives that indication, then respectfully, the party has made an election to adduce evidence. And my lords, that is the basis on which the court made orders at the stage of case management as to when witness statements should be put in. The court made orders on the basis of the election that they had.
No, Mr. Gibbs, a point of correction. The orders for witness statements is made at the application for direction stage and not at the case management.
The orders
is made on the order 32. Yes, at the application for direction stage.
But my lord, that is the situation here is different from the pure high court situation, because in this case, at the case management stage, in this situation, we did not have a direct application for directions, my lord. We did not have that. I believe that's common ground between us. So in this case, we move to the case management stage. And in the case management stage, the court makes orders on the basis of representations that are made to the court by the parties. And respectfully, the representation that was made to the court at that stage is that we are going to call a witness, and we will provide a witness statement on behalf of that witness. That's the clear indication that they gave. Otherwise, the court would not have made an order, submit your witness statement by such and such a date. That is very clear, my lord.
I wish to come in, Mr. Chikata. Now, are you saying that if you decide to call 5 or 6 witnesses and you put in 5 or 6 witness statements, you cannot at any point in time tell the court that though you have put in 6 witness statements, you are not going to call all the 6? Can't you say that?
My lords, you can say that.
Yes, please.
My lords, you can say that, but that is not what is dealt with in Order 36.3, which is what they're coming.
You see, under the normal civil procedure, if the prosecution closes its case, and that may be the plaintiffs. That's what I'm using prosecution in the civil sense, for the plaintiffs.
My lords, with the greatest respect, yes, let's just stick to what we're familiar with. If you say prosecution in the civil...
Okay, so if the plaintiff closes his case, and the defendant realizes that the case the plaintiff has made has no substance, or does not establish the reliefs he is claiming, and there will be no need for him to testify, you know, he can tell the court that he will not testify, and then he will be put to his election. Whether if the court rules in respect of his application, he will still testify or he will not testify.
My lord,
that is the procedure.
My lord, with the greatest respect, that is not the procedure under our rules. With the greatest respect, that procedure may apply under the English civil procedure rules, but it does not apply under our rules. And with the greatest respect, if I'm wrong in that, I would stand to be corrected. Which rule under our rules has that provision?
It's a settled practice.
My lord,
that we adopt. So are you saying that
my lord,
a party cannot say that I will not testify, judge the case according to the evidence you have?
My lords,
because you cannot compare anybody to testify.
My lords, with the greatest respect, my lords, with the greatest
order in court, please.
With the greatest respect, I wish to take it a step at a time. If your lordship is referring to a submission of no case at the end of testimony, if that's what your lordship is adverting to, my respectful submission is that, one, under English common law, it is in fact not available in a trial which is not before the jury. Under common law, the authorities are clear that that process that your lordship just described is not available. And I am prepared to cite some authorities in the common law which make that clear, including a well-known case of Alexander and Rayson. But my lord, before coming to that, I just wish to clarify that the common law position is very clear. Where there is a jury, it is open under the common law. Where there's a jury, it is open for where there's a jury, it is open for the plaintiff to say indeed that I don't want the matter to go before the jury. I'm ending at the point of the trial judge. But the common law position that has been clearly stated in the English Court of Appeal is that where there is only a judge and not a jury, that procedure is unacceptable. And there's a very clear reason given for it in the authorities, which I'll come to. But my lord, I want to...
Mr. Chigat, I want to understand something. Are you suggesting that a party can be compelled to give evidence?
My lord, that is not what I'm suggesting. I'm just suggesting that Order 36, Rule 3 applies in terms of the precondition that is put there. In terms of the precondition, it says where the defendant elects not to adduce evidence, then whether or not the defendant, and I'm saying respectfully that in this case, the first respondent elected to give evidence and notify the court as such. The first defendant elected to give evidence, notify the court as such, and on that basis, the court made an order for a witness statement to be provided.
Mr. Chikata, you are aware that at case management stage, nobody knows the evidence that the other is bringing. It is after case management audits that the testimonies come in. Is that not it?
Very clear. I mean that's a matter of chronological necessity, because that is a chronological necessity. A case management happens before witnesses are called to testify, so there can't be any doubts about that. I'm referring to the fact that under Order 36.3, which counsel for the first defendant is seeking to come under. And my lord, this is also different from the submission of no case under the common law.
Excuse me, Order 36.4, sub-rules 2 and 3 together. You say, subject to sub-rules, the plaintiff shall begin by opening the plaintiff's case. Then 2, where the defendant elects not to adduce, 3, where the defendant elects not to adduce evidence. It presupposes that the plaintiff has finished his case. That is my understanding. I stand to be corrected.
My lord, respectfully, that cannot. Respectfully, that cannot be the case. Because my lord, Order 36.4.3, and respectfully, as I said, those rules predated CI 87 on case management. CI 87 introduces case management, on the basis of which your lordships have proceeded and given orders. And respectfully, I'm submitting that under the terms of CI 47, Order 36, Rule 3, where the defendant elects not to adduce evidence is a precondition for that. And in this case, the defendant at the case management stage represented that they would adduce evidence, and therefore that precondition does not exist. And the defendant made those representations to the court and to the court in a manner which led your lordships to determine.
Mr. Chikata, may I seek clarification?
Yes, my lord.
Are you suggesting that under the case management regime, a defendant who indicates to the court before evidence is taken that I will call one or two witnesses in this matter, then after the plaintiff has given evidence, the defendant says, I don't think I need to call any evidence. Determine the matter on the basis of what the plaintiff has brought. Cannot do so?
Yes, my lord, I'm saying that he cannot do so where the court, on the basis of their representation, has ordered witness statements to be submitted. Because where he does that, he has elected other than what is provided for in Order 3643. Where he makes that election at the case management stage, and the court has made an order appropriately.
Mr. Secretary, you realize that Order 36 Rule 4 is only regulating order of speeches.
My lord, I didn't quite.
Order 36 Rule 4.
Yes, that's the
it's only regulating the order of speeches. That's all that the rule is seeking to do. But I try.
Yes, but my lord.
But how can the law say that a party compel a party to give evidence by all means?
No, my lords, respectfully, if you say that the order of speeches is all that.
Yes, order of speeches.
Yes. My lords, that's a head note, and your lordship knows very well that the head note does not settle the interpretation of the provisions. I mean, Bernard Mona's case is a classic instance where the head note was shown to be completely different. And in fact, if we were only dealing with order of speeches, then my learned friend is completely out of court, because if that provision is only to do with order of speeches, then he cannot, on the basis of that, be asking your lordships to do or be telling the court what he told the court. If it's just order of speeches, then it will be interpreted as such. So it cannot be just order of speeches.
These proceedings are...
I'm sorry.
Order 36. These with proceedings are trapped.
Yes, but Order 36.4, as his lordship pointed out, is order of speeches. That's what your lordship pointed out to me, and I agree. It says order of speeches. And I'm saying that the head note cannot limit the terms of that order, respectfully, because in fact, if your position were to be accepted, respectfully, then you should throw him out of court completely, because we are not yet at the point of order of speeches. We are not yet at that point. So if all that 36 Rule 4.3 is dealing with is order of speeches, then all he said is irrelevant, because we are not yet at order of speeches. But the reality of the matter is that that head note cannot limit the terms of Order 36 Rule 3. I believe that.
Mr. Chikata, isn't compelling someone to testify a human rights question?
Also, my lords, I'm sorry. My lords, this is new territory. I mean, I have to think of it because frankly,
because nobody can compel a party to testify.
My lords, frankly, I have to give considerable thought. In fact, I have to give considerable thought to what you're saying. That you're not.
I mean, as I'm sitting here, I'm reviewing this whole thing.
Yes.
I mean, nobody can compel a party to testify.
My lord,
that's a very basic rule.
My lady, as I said, I mean, your ladyship has been part of a ruling in this court which said the right to vote is part of the directive principles of state policy.
Chikata, please, may I have your attention?
Yes.
Please, none of us, at least those on the bench, none of us anticipated this step. So please come, both of you come and address us on this point tomorrow. Then you will give a ruling on it and then proceed accordingly.
My lords, I was actually going to make a similar submission because it is my respectful submission that for an application of this nature under Order 19, it should be made in terms of a motion paper and a supporting affidavit so that we can respond appropriately. Because, my lord, that application that is being made...
Please, with all respect, please, there's nothing factual about this application. Yes, let's take it. If he comes tomorrow to raise this legal issue, you have the opportunity to reply. So please, just prepare.
Very well.
And bear with us tomorrow.
Very well. Very well.
Yes. Please, we want to know your position because you have also filed a witness statement.
Yes. My lords, we do not intend to call any witness.
Okay, then you prepare.
And my lord, let me complete. Order. We do not intend to call any witness because in our view, they have not satisfied the burden of proof. So we can't be forced to call any witness.
We don't want lengthy answers. Please, what we want you to do is to prepare, come and address us on it tomorrow. Then we will give a reasoned ruling on it and proceed accordingly. Thank you very much. Please, you will rise for the day.
Well, the end of this day 6 of the election petition trial is turning out to be rather very dramatic. But it looks like we have to take you back into the courts.
Immediately after proceedings, counsel from both sides resort to granting interviews to the media. And at times, some of them keep on twisting the facts, which actually occurred in the court, and seek to even prejudice whatever the court proceedings were. So lawyers who are engaged in it are to please have a look at Regulation 55 of LI 2423. Yes, that is the legal profession etiquette, conduct and etiquette rules. Please, if I may read 55C. So, a lawyer shall not publish or cause to be published material concerning current or potential proceedings, including proceedings for which the lawyer is engaged or seek to be engaged, which is inaccurate or has received comment or necessary description. Then C, is calculated or is likely to a material degree to diminish or be prejudicial to the public confidence in the administration of justice. Please, I think both sides have been guilty of it, and especially my dear sister, Marietta. At times, yes, you made statement even touching on the demeanor of witnesses. So please, it's a passionate plea from the bench. Let's respect the ethical rules. Yes, Mr. Opontu, you were also guilty of it because you were at the news file, and we think that since you have been announced in this case, it is unacceptable. Yes, Mr. Menuvo, your name appears on this LI. Yes. So please, yes, as a member of the General Legal Council. So please, let's take our own rules seriously.
Yes, but my lord, speaking for myself, I have never...
No. I'm drawing your attention to it. Your name appears.
Yes, my lord.
Yes.
So it is encouraged you not to do.
Yes. My court, this petition is hereby adjourned to Tuesday, the 9th of February 2021 at 9:30 a.m. for legal arguments. It's okay.
You don't need a wig. No, you don't need it. You don't need it at all.
All rise.
So some fresh development from day 6 of the election petition trial. First, there's been some proposal. Well, not quite, because the EC, after hearing from the witnesses from the petitioner's side, we were all looking forward to the EC putting forward its witness. But the new development is that they are not. They've opted. The Electoral Commission lead counsel has stated in court today that they've opted not to put forward their witness, Jin Mensah, according to what they are proposing, what they put on the table now. They are not putting Jin Mensah in the box. They do not wish to lead any further evidence beyond the witness statement that they have presented to the courts. So evidence in chief, which is the witness statement, it is supposed to be subjected under cross-examination. They are not putting forward their witness, Jin Mensah. Effectively, what it will mean is that this is the end of the cross-examinations. We won't see any more witnesses enter the box, because the second respondent in this case, which is Mr. Kufuor's lead lawyer, Koto Ampao, has also disclosed that they do not intend to call any witness. So we will not see Peter McMahon. Well, if this is granted, if they make their argument and the court decides to grant this, then it means that we will not also see Peter McMahon enter the box to be cross-examined by the petitioner's lead lawyer. That's the very fresh developments from today's procedures, of course, after Roger Mettle-Nunoo's cross-examination. Towards the very end of the procedure today, though, the courts, the Chief Justice has spoken. He says granting of interviews, sometimes the lawyers tend to twist the facts, and their comments can be prejudicial to the processes going on in court. He says both sides have been guilty and refers them to the Legal Profession Code of Ethics. He wants them to respect the etiquette rules, and he specifically made mention of Marietta Brew Apia Opong and Yao Opong. Apparently, he cannot continue to be on news file. That was specifically mentioned. Remember the first time that a lawyer was called and was essentially told to be careful. That was Frank Davis, who's part of Mr. Kufuor's lawyers. He was specifically mentioned, and after that, we didn't see him address the press as he usually did. But today, Marietta has been mentioned and Yao Opong has also been mentioned. It will be interesting to see how the addresses go after today's procedures. Of course, that's something that traditionally they do. It has come to stay with this particular process, where the two sides or two of the sides will address the media. We'll get our court correspondent to tell us about some of the backstories in terms of how people are responding to this fresh twist of events with the processes perhaps ending with the cross-examinations after the 3 witnesses from the petitioner's side, Johnson Asiedun Ketia, Dr. Pesa Whites, and then today Rojo Mettle-Nunoo. Is this the end of the cross-examinations, as the EC's lead counsel has disclosed in court today that they do not intend to bring Jean Mensah in the box? Chacha Chikata tried to oppose that it's not up to counsel to take this course that they are proposing that they are going to take, where they elect not to adduce evidence, where he also puts it this way, that they're running away from cross-examination. The Chief Justice came in and wanted him to change at least the word. He says evading will be a better word to use in this case. Well, the court says tomorrow they should appear and make their argument. So there will be legal arguments for what is on the table in terms of the EC not putting forward a witness. Also, the second respondent, Mr. Kufuor, also not putting up a witness. We will see what the order will be. We'll try and get some legal education around all these matters. Our broadcast is in association with Petrosol, Co-op Mixture, and DBS Roofing. It's our election petition update. Very shortly, we will talk to our correspondent Joseph Akable, and of course, we'll be looking forward to who will be addressing the press and how will that address go from both sides. What will they say? Will they be mindful of the advice coming from the bench? This is the second time, by the way, that the bench is taking notice of the speeches outside the courtroom, and we are asking the lawyers to stick to the legal ethics. So we're curious, how would it go today? We'll bring you that, of course, live here on JoyNews. We will also be speaking to Samson Ladi Ayenine. Let's get some clarity on some of the matters. In the meantime, court has adjourned sitting to tomorrow, Tuesday, at 9:30 a.m., where we will see legal arguments being made on this issue of no further witnesses from the 2 respondents. All right, let's go to the Supreme Court now.
One, the issue of double for particular reasons. So, for example, it has 2 sheets with different numbers on it, and yet the same valid votes. And in court, we saw that apparently there was a third one lurking somewhere with a different timeline. We also saw that, for example, if you read his witness statement, Greater Accra was also an issue. Greater Accra, the numbers on the sheet did not add up. And interestingly, if you read the witness statement, you see that what was published, or the summary that was published on the website or by the EC, was different from what was actually given to the agents in the collation room. The other thing that came up was the fact that this was the National Collation Center where the returning officer, Jean Mensah, was supposed to be in control. We heard from their cross-examination that for a period of 3 hours, the agent of the petitioner was trying to get his problems or the issues that he had seen across to her without any success. We also saw the fact that they state that if you have signed the sheets, even if there are glaring problems on the sheets, nobody is going to do anything about it. This should give us all cause for concern. But even more importantly, is the fact that Roger Mettle-Nunoo reiterated under cross-examination that it was the EC chair who asked him to convey message, information, whatever you describe it, to the petitioner. And if you read the witness statement, you realize that it was about a potential stakeholder meeting to discuss the concerns they had raised. And of course, as soon as they left, the EC and its chair, Jean Mensah, made arrangements to declare the results. Now, all these are issues of concern. Now, you probably would ask, how does this relate to the reliefs? If you have several collation seats for one region, which one was used for the declaration? I don't know. If you have sheets with different words in numbers in words and numbers in figures, which are different, which one was used for the declaration, or for collating, or for adding up the numbers? The only person who can tell us this is the EC chair, who's the returning officer. And that leads me to the second issue that rose today. They claim that they are not going to, or they stated, it's not even a claim, they stated clearly that they are not going to call any witnesses, even though they have submitted witness statements. Now, I don't know whether it's evading, running away, whatever, but they are avoiding or running away or evading the cross-examination of Mr. Chikata. We should remember that this is the EC, which has a constitutional duty to the people. They have an obligation to account to us for our stewardship. And they say they are not going to take the witness stand. Well, tomorrow we'll see how our lordships will rule on this. And the issue was raised whether it's a human rights issue. I don't know. This is the EC chair, a body created by the Constitution, which has an obligation to account to us. They are obliged, they have a duty to respond to our questions. They cannot, EC cannot hide under human rights to say they are not going to respond to us. So I respectfully disagree with her ladyship when she said it is a human rights issue. It is not a human rights issue. They are obliged to respond to us.
Thank you very much for this. I'd like to find out, you have closed your case today. You've closed your case today, having called 3 witnesses, Asidun Ketia, Roger Mettle-Nunoo, and Mr. Michael White. Having listened to them give evidence, would you say that your case is still tight? You intended to call some more. You advertised for 5. And when you asked the court for an application to look at documents within the EC, you were shut down. You now have 3. Would you say that you have a stronger case still?
Wouldn't I say that? I couldn't hear.
Your case is still strong?
Yes, I think we still do. Because there is the issue of the declaration, which is why we are in court, where we stated clearly that even on the face of their own documents, nobody got 50 plus of the votes, of the valid votes. And in addition to that, as at now, the EC itself has come up with different figures. They are ever-changing figures. Which one is the valid votes which is supposed to be used for the declaration? They haven't answered that question.
Yes, Counsel, you have filed a petition making the point that no one got more than 50% of the votes cast. Each time your witnesses have been cross-examined, you've told us that you were satisfied with what has transpired. Should it not be in your interest that you've closed your case and the respondents you are seeking reliefs against are saying that, look, we don't intend to lead any evidence to show the contrary, that people had more than 50% of the votes cast? I mean, should that not be good news for you, actually?
Let me say it's of concern to us, and that is why we are going to oppose the application tomorrow.
Maybe closely linked to that, or following up on that, is a question of the relevance of that particular cross-examination to your case. The lead counsel for the Electoral Commission had made in his submission that indeed they are satisfied with what you have brought to court, and they think that the court can go ahead and make a determination without the benefit of the testimony and cross-examination of the returning officer. How crucial is this cross-examination to your case?
First of all, if we did not have a case, then they should not have filed any answer. Then they should not have submitted any witness statement to the court. Each of the parties have submitted witness statements. But my major concern is with the EC. That is accountable to all of us. The EC cannot say that it will not respond to questions raised by a petitioner, by a candidate. That it will not respond to questions raised by a petitioner, by a candidate.
One question that ran through the cross-examination is, with all the three witnesses you presented, is, do you have figures that shows that the second respondent did not get the figures, I mean the percentage that he had? That was one of the questions that ran through. I want to find out, you realize that, I mean, no figures have been provided by the witnesses and then the petitioner. Do you think with this, the court will grant your reliefs? Because the question that went through was, do you have figures that show that the second respondent did not get the percentage that he had?
First of all, please go back to our reliefs. Go back to the declaration. Go back to the different figures that have been churned out by the EC. I keep answering this question. I've already answered it. That by the declaration, by the different figures that have been churned out by the EC after the declaration, it is obvious and it is clear that no candidate got 50% or more of the votes. As to whether, what was the question? I mean, with regard to our figures, that's irrelevant to the case. We've come with the EC's declaration itself.
I have a question. How compulsory must Jean Mensah's cross-examination be for your case to succeed? In other words, is the success or otherwise of your case hinged solely on her cross-examination? And if that fails based on what the bench will rule tomorrow, would you then determine that you have a lost case because you are unable to cross-examine them?
Of what you're saying.
If the bench rules tomorrow that she should not be cross-examined, would that throw your case out of the window automatically?
Well, first of all, we'll take it from there. We are going to argue whether or not the EC and the second respondent should take the witness box. Our view is that they have an answer there. They have submitted witness statements, and they ought to be cross-examined on those matters stated there, because that is what they are using to challenge our case.
Yeah, but so my question is, yes, your argument has been put forth in the courtroom. Now the determination will be made by the bench tomorrow. is the success or otherwise of your case hinged solely on this cross-examination? That's the question.
You note that when you go to court, your case is not just based on your pleadings and your evidence. There is also an answer, and in this case, there's also a witness statement. And we think that it is important for us as petitioners to be able to cross-examine the EC in particular on the matters that she said.
And one of the lawyers mentioned in court today addressing the media on behalf of the petitioner. So Marietta Brio Apiao-Hong speaking there and expressing the opinion from the petitioner's side in terms of how the case have gone today, the disagreements with the no witness being put in the box that was made by the two respondents. She's strongly saying that they disagree with that position and they're going to be making their case, that argument in court tomorrow. But let me just do a bit of a summary. Roger Mettle-Nunoo's witness today brings the petitioner's case to a close. They are not calling any more witnesses and they have made their case. The expectation really was that the first respondent in this case, the Electoral Commission, would put its witness, Jean Mensah, in the box next. However, lawyer for the EC disclosed in court that in view of the evidence seen so far by the court, there is enough evidence for the case to be determined. For the case to be determined, which means for this petition that has been filed by John Dramani Mahama to be determined from everything that is before the court presently, and that they do not wish to lead any further evidence. They have also effectively closed their case. The other respondent in this case, the second respondent, Mr. Ekufuado's lead lawyer, also disclosed that they have also closed their case. They do not intend to put any witness in the box. Of course, we were expecting, the expectation really was that Peter Makumenu, who filed a witness statement too on behalf of the second respondent, will also be put in the box. That's an issue for determination by the courts. The court has adjourned sitting till tomorrow. The lawyers will continue making their arguments for and against, and of course, the court will rule. But what does this all mean where we've gotten to presently? We'll try and get some legal education on this. We're also expecting that the other side will address the press, but Samson Ladi Ayenini has joined me now for us to do for him to give us, some kind of clarity on some of the things that we're witnessing. Samson, is this a surprising turn of events, or this is totally normal in processes like this?
I'm trying to get my video on, but it's disappointing me. So we can go on, right?
Yes, we can.
Right. Okay, so in this our practice, surprise is part of it. And like I said earlier, every lawyer has a strategy. And the strategy has the end game in mind. Now, when it comes to criminal trials, this is a strategy that almost every defense lawyer likes to use by saying, we want to have a submission of no case. Now, this mimics that kind of, process in the civil case. In the civil case, you are not doing a submission of no case, but you're saying that at this stage of the trial, I take the view that getting my witness into the box to continue the process in oral testimony is not necessary. So I do not intend to put my witness in the box. Now, Mamavi, it may be tricky, but it's easy to understand. When you take that decision that your witness is not going to be in the box, you do that, in fact, at your own peril. But you must have made the calculation to come to the conclusion that even without my witness getting in there, my case is made and I will not lose. So we should look at what happened in two ways. That is, now that they have been invited to come and argue on the question, we should look at it in two ways. If the defendant, as in the respondent, wins this particular argument, and on the part of the second respondent electoral commission.
Something, apologies. We will continue this. I just want us to cross over and take the side of the second respondent addressing the press.
Admitted that they have formally closed their case. I'll speak about what that means and what it means for the next step. Prior to that, you saw the petitioner put in the box his third witness, who I believe many people were hoping will help adduce evidence that will advance the petitioner's cause. It is not for nothing that anytime we come before you, we go over the issues that the court is seeking to determine. Because sometimes you may hear they are in court, they are in court, but the issues may get missing. So please permit me, when I repeat the issues, what the court is seeking to answer. The court on the 20th of January 2021, after listening to the petition and the answers and reading the memorandum of issues, set down the following issues for the determination of the petition. All of the conversation you hear going back and forth is about these issues. And the petitioner is being required to bring witnesses to adduce evidence to settle these issues. Issue number two, because the first is an issue of law that the court will determine. Issue number two, you're expecting that when witnesses mount the box, they will provide evidence to the effect that based on the data contained in the declaration by the first respondent of the second respondent as president-elect, nobody got 50%. You are expecting that when a witness mounts the box, the witness will provide evidence to the effect that the second respondent, if you include or exclude Techiman South, did not cross the constitutionally mandated threshold of 50% plus one. You would expect that when a witness mounts the box, that witness is adducing evidence essentially that will prove that the declaration of the first respondent on the 9th of December was in violation of Article 63.3. Or at least you expect that what the petitioner has listed as errors in the petition, this witness will provide evidence that shows that these errors and these alleged vote padding affect the outcome of the presidential election 2020. So far, we have seen the petitioner put 3 witnesses in the box, and we are of the view that the court will do a good job in determining whether or not these witnesses have provided any evidence that supports the petition and these issues that the court is seeking to determine. Now, it is upon the completion of this, and note that the petitioner advertised 5 witnesses and ended up calling 3. It is upon the completion of that the petitioner has now announced to the court that this is all that the case is about. And you heard Mr. Chikata say, "My lords, our case is closed." And His Lordship, the Chief Justice, say, by court, the petitioner's case is closed. If we were in a criminal trial, what will happen now is that the court will have to determine whether or not a substantive case has been made, in which case the defendant or the defense may now raise an argument that maybe no case has even been made. So I don't even need to bother raising a defense in the first place. In a civil process, there are similar remedies. What you noticed happened, which is the second matter I'll speak about, is counsel for the first petitioner announced to the court that the evidence, counsel for the first respondent, I beg your pardon, announced to the court that the evidence that the petitioner has provided is enough, and the cross-examination that has taken place is enough, and that the first respondent does not intend to call witnesses to adduce evidence, any further evidence before the court. And counsel on the side of the second respondent has advertised same, because by now, whatever evidence that the petitioner has put before the court, once the case is closed, it is believed that they have brought all their evidence and they have made such a strong case. And so it should actually be to the disadvantage of the respondents if they say that they don't even intend to call witnesses to adduce evidence. But you notice that the petitioners are not too happy about it. They want literally to compel the respondents to bring in witnesses to, I don't know, adduce some evidence that may help the petitioner in his cause. The court has adjourned, as you heard, to tomorrow morning, and we'll listen to the legal arguments on both sides. We are very, very happy, extremely happy that the petitioner has come to the end of his case and has adduced all the evidence that he has. Evidence which is supposed to prove that nobody got 50%, that whether or not you add Techiman South, the winner will change, that Article 63.3 has been breached. This is all the evidence that they have, which they have made available. And we'll hear what the court says tomorrow as it proceeds to deal with the matter. Yes, sir.
Okay, I think. Thank you very much. You have said umpteen times that you intend bringing at least Mr. McMahon to testify. I know you're not responsible for the first petitioner's witness. They have said categorically that they will not present her to testify. But why has the narrative changed? At least we know that Mr. McMahon was going to be in the witness box. Thank you very much.
I want you to go back and play the tapes of our press briefings here. The narrative has not changed. We have always insisted that the onus of proof lies on the petitioner. Sections 14, 17 of the Evidence Act are very clear. He who alleges must prove. You have told your supporters across the country that you won and that they should get on the streets. People died. People got injured. People got involved in infractions with the police and got arrested because you told them you won. When you came to court, you abandoned that and said, nobody won. And the court has invited you to prove. We have always maintained that we are waiting for their witnesses who will adduce evidence to prove that at least their second argument that nobody won is true. And we have always maintained that Chairman McMahon is ready on standby, that when they prove this and it becomes necessary for us to go into the box and prove that what they are saying is not true, because they would have made a preliminary case, we will do so. You have seen their three witnesses. The court has seen them. The whole country has been watching. We've all been waiting with bated breath to see the evidence that nobody won. To see the evidence that when you add or you don't add Techiman South, the results will change substantially to mean who crossed the 50% threshold. To see the evidence that Article 63.3. And on our side, we are not convinced that any such evidence has been put in. That is why we have announced to the court that we don't intend to call any fresh witnesses or any witnesses, because on our side, the view and the belief is that that case has not been made. So the narrative has not changed. The whole country has been waiting. All the NDC supporters, I'm sure, have been glued to their TV, waiting to see their officials prove that nobody got 50%, or that at least the first argument holds true. Now they have announced to the court that they have finished their case, and I'm sure many people are surprised. Now the second part of your question about why Chairman McMahon will not be taking the witness box. A party advertises to the court how many witnesses it chooses to call, or its intention that it may call X or Y or Z. And as you heard the bench in exchanges with the lawyers, there are questions about when that election takes place, which I think questions will be addressed yesterday. But isn't it interesting that Mr. Mahama himself, the petitioner, did not mount the witness box? And we are not arguing about why he's not in the witness box. Why has he not taken the stand? Why has he not taken the witness box? Can anybody force him to take the witness box? The petitioner himself. Even to court, he has been here twice, and other representatives come on his behalf. Can anybody force Mr. Mahama to take the witness box? Can anybody force the other 2 witnesses of the NDC that by force they should get into the box? So if you're asking about Chairman McMenu's or the announcement that we will not be putting anybody in the box, as I've mentioned, it is because our lawyers are of the view that that basic threshold has not been met. They have not adduced any. I don't know if you have seen evidence that shows that nobody won the election or that 63. This is what they told the country. This is what they told the court subsequently when they came. And our lawyers are of the view that that hasn't happened. That is why nobody will be bothering to take the stand. And tomorrow they will advance legal arguments to that effect. But if your question is about why he isn't taking the stand, maybe we should ask why Mr. Mahama is not taking the witness box as well, and why they are not bringing the other 2. Yes, sir.
Counsel, if it happens that tomorrow, we don't know, the justices agree on the other side that the witness, the EC chairperson should stand in the box, are you going to call Mr. McMenuoo eventually? The
calling of Mr. McMenuoo is very different from the EC's posture. Mr. McMenuoo is representative or is a witness for the second respondent. We are of the view that the petitioner has not crossed that threshold, and that's why we have announced to the court that we will not be calling Mr. McMenuoo to bother to even give any evidence because no substantial case has been made. That is the opinion of our lawyers. Now, should the EC change its mind, or should the bench decide that the EC should go in and answer? It has nothing to do with our side. We have made a case. The court will make a determination on whether or not we should be forced to put a witness in the box when we are of the view, and the evidence, I think, as has been seen by many, is in question about whether or not they have made a case as they had advertised earlier. Yes, sir.
All right, sir. I believe that this is in the interest of all Ghanaians, and irrespective of the fact that this is between the petitioner and the Electoral Commission and Nana Akufo-Addo, Ghanaians are also expecting an answer from us. And so I'm asking that why don't the second and first respondent allow EC to step into the box so that he will clarify some notions made in some heads of some people?
Yeah, I think that's a very good question. Last time you raised a similar question, I made the point that this is a court of law, not the court of public opinion. This is, with the greatest of respect, this is not the Public Accounts Committee of Parliament that the EC must give us some answers. This is not budget hearing of Parliament that the EC must come and justify its budget. You have come to court with a specific petition, and the onus of proof is on you to show to the court that this is the basic case, and therefore somebody has a question to answer. Where you have not met that threshold, you cannot resort to what I keep telling you are propaganda answers. That when you lose the legal battle, then you resort to propaganda questions and answers. That, you know, it's in the interest of all Ghanaians, and so why there is no. And let me also make a distinction. In the 2013 election petition, the Electoral Commission mounted the witness box. Why? Because the petitioner came to court with results of about 11,000 polling stations, pink sheets to back same, and to make an argument that when you deal with the lack of signatures, the multiple serial numbers, etc., which are all infractions, and you strike them out, you have to call a proper declaration of the result that Nana Akufo-Addo is the winner of this election. He came with evidence and made a case. You have been here, and you have heard the bench labor asking the petitioner over and over again, where are the numbers? Where are the numbers? Where are the numbers? And time again, they make the point that it's not even relevant to their petition, and that they are not here looking for new numbers or anything, or a new declaration, but they are here to question the conduct of the EC chair. The two cases are very different. One came to court with pink sheets and evidence, and the petitioner in 2013 mounted the witness box. Dr. Alhaji Mahmoud Baumia, who was one of the petitioners, mounted the witness box to advance his case, made the case, and therefore the EC had to get in the box to respond. You have been here. Have you seen their pink sheets? Have you seen their regional? Have you heard them answer the questions when the bench puts the question that what are the numbers? So the two cases are different, and it's not that is in the public interest or is in the public interest. This is a court of law, not a court of public opinion. Yes, sir.
it is true that the petitioner has not been able to give out any figure that show that the respondent did not win the election. But the argument they are making is the consistent change of figures by this first respondent is the reason why they are in court. And you think they have no case?
The court has said that as the last issue to determine whether or not these so-called errors materially change the result of the election. It's one of the issues that the court is going to determine. And that is why at every material moment you hear, for example, the Venerable Akoto Ampao, and today you heard him ask that same question of Ruju, that I want to suggest to you that this your 1,700 or so that you are talking about is not material enough to affect the outcome of the result. You heard that question, and you heard his answer. He was being evasive, but you heard his answer. The point is that the so-called errors, or the phrase that they like to put out, the propaganda phrase they put out, the ever-changing results, like how they put it. Even if you admit that those are substantial errors, the question is, does it change who won the election? If somebody beats you by 500,000 votes, and you come and you say, I saw 1,700, which I describe as vote padding, the court wants to determine whether or not it is substantial enough to change the result. And that is why at every point in time, we keep asking them to provide the court with those numbers that will show substantially that it can change. And you hear them over and over again decline so to do. I think that for the millions of NDC supporters who are watching across the country, they will also be asking questions. Because now there's a clear difference between what the petitioner and his colleagues told them on the night of the election and what they are saying in court, and some of the admissions they are making in court. For example, you heard Mr. Roger Mettle-Nunoo admit that for almost 3 hours, he had left the strong room and was at the reception of the commissioner and admitted that he was having tea, but then, argued that there were no biscuits involved. These things may sound as funny, but the supporters of the NDC down there across the country will be asking themselves that, so while they were out there, having been misled that they had won the election, this is what their seniors were doing at the premises of the Electoral Commission. This is what they told the public. And now when you come here, you have to make some admissions. So the jury the bench will make a determination at the end of the day. Colleagues, are there any other questions? Let me yield the podium to my colleagues to translate it.
All right, and that's the legal team spokesperson of the second respondents, Nana Dankwa Akufo-Addo Kojo-Ponkroma, they're addressing the press. Will try and raise Samson Ladiayenini back. We'll also talk about the matter of granting of these interviews. Samson is with me now. Samson, thank you for your patience. You are in the middle of addressing the issue of how things have turned out in terms of we're not putting witnesses in the box, and you say this may work or may not work.
Right. So, Mama V, the thing is that I'll refer you to one case which happened in the Supreme Court. It may help us understand. And this is what the court had to say on an issue like this. It said that if, and I'm paraphrasing, if the defendant, so if you like in this case, put respondents, if the defendant, in the bracket respondent, is opposed to opening the oral hearing, he should not be compelled to. This was in the Supreme Court in 2012 in the matter of Sumaila Bielbil versus Adamu Dramani Sakande and the Attorney General. It's a question of privilege versus obligation. Is it a question of privilege, or it is one of obligation for a defendant in a case to after the plaintiff, and in this case the petitioner, has closed their case to enter the witness box to adduce evidence, is it privilege or obligation? By my reading of the law, it is a question of privilege and not obligation. The reason it is privilege and not obligation is what I mentioned earlier. You elect that path at your own peril, so to speak. But if you have examined everything and you take the view that without you getting into the box and to say something further, you still win your case, your case is still good, then you are entitled to say back. So in that case, the Supreme Court, speaking through Daba Samuel Kofi Databa, the man you love and have been reading his book on the Supreme Court, giving us insights into what they do, which we rarely get to know how they do what they do to bring out the judgment. He says in that judgment, which is binding on all of us, as in the lower courts and everything, but the Supreme Court is entitled, to change its position from time to time. It says it is a question of privilege and not obligation. Since it's a question of privilege, one should not be compelled. I suspect this is where you had the majority of the judges coming in and asking the Venerable Chatuchikata the questions they were asking. So, when we started all this discussion, I said every lawyer has his strategy. And in this game, strategy is sometimes as good as your law. So this is their strategy.
Okay.
Now, once they say that they don't want to call their witness and that day too they want to close their case, it means that Chatuchikata can elect to have the witness statement that Jean Mensah has put in, and if the first respondent, Nana Akufo-Addo, also decides that he doesn't also want to, continue by calling his witness Mettle-Nunoo.
Which is what it is, because that's what they proposed.
Right. Then what they have to do, what the Chachu will have to do, may have to do, not will have to do, will be to ask the courts to treat the witness statements as hearsay evidence. Now, in law, when evidence is treated as hearsay evidence, the value you put on it is entirely different from, statements that have been tested in the judicial process. So that's where we are. Let's see how it goes tomorrow.
Okay.
But I can say that it's a very difficult hurdle for the petitioners to seek an order compelling parties who do not want to get into the witness box to get into the witness box.
So, Samson, you lawyers say that the witness statement is evidence in chief. It is supposed to be subjected under cross-examination. So that's
right.
So in this case, we won't see, for instance, first of all, would it be tendered in? Because as we understand it, it's not a document that has been tendered in.
So, like I said, the rule is that, and these are the new rules. The new rule in CI 87 is that if a witness decides by their own election that they are not going to go in because they believe that, they have nothing to lose, then you, the other party, can now decide that, it goes in as it should be treated as a hearsay evidence.
Okay.
In fact, they can actually elect to also ask that should be it. It should be treated as hearsay evidence.
Okay, so Samson, in other words, can they also decide that they're not going to put the witness statements through?
Oh no, they can't say that. Okay. What they have said is that they do not intend to adduce evidence. You see, when you go to court, you go and fight the case on the strength of your own case. You don't fight your case on the weakness of the other party's case. If I say that you entered into a contract with me, and by the contract, you were supposed to pay me X amount after I have performed the contract to a certain extent, and that if I breach that obligation, then you will resort to the court. Now, if you decide to come to the court to say, I have not fulfilled my part of the contract, you must leave the evidence to show that I have not. You should not wait and hope that when I am put in the box, I will say things that will give answers to show that what you are saying is correct. So first, pleadings have been put in. You file your case, they file their answers. In their answers, they gave the explanations that they needed to give. Those pleadings are there. You get to the point of adducing evidence, and they say, at this point, we don't feel that we should even go on and say anything any further. In the normal circumstances, the one refusing to do that or electing to do that, the one that was expecting that other one to do so should be excited that I have put my case forward, and you failing to put yours through the test, you will have a difficulty, you will fail. Unfortunately, it doesn't look like the petitioner feels this way in this matter. But you look at it very critically on the face. That's how, in the ordinary sense, it should communicate to you. I am supposed to get in to improve my case and my chances of my case. And I say, oh, I don't want to get in. I am supposed to be thinking I am losing if I don't get in to establish my case properly. But this is where we are.
Okay.
And you see, don't forget that we are not through yet. Supposing they bring their arguments tomorrow, and still, like I said, this is a very difficult hurdle for the petitioner to argue that the respondent must at all costs go in and be compelled to go in. Because, like I have explained, they have their defense and they say, I don't want to do it anymore. So capitalize on that and win.
Okay.
Now, we haven't ended yet, because the lawyers will now do, if the petitioners lose this opportunity to seek to compel the respondents to get into the box, they will do oral addresses, or if you like, the written addresses. So every party will write and say this and say that and say this. In the addresses, the petitioners will spend sufficient time to say why the defense of the respondent should fail and that their case should prevail on the basis, including of the decision of the respondents not to adduce evidence.
Okay.
Yeah.
All right. Okay, so I'm saying I want to say thank you, but you know, Yawapong may not be a news file on Saturday, apparently.
Maybe I have been out of sight and out of hearing. What are you saying?
Samson, thank you very much for your time and for the education as well. Samson Ladia Yenini, of course, is host of Newsfile. He missed that bit of the courts, but he'll do a playback. I know he will. Joseph Akablazer, court correspondent, he joins us live now from the Supreme Court. Joseph, I have been sitting here and been saying that this been a twist of events. I wonder what people in the court thought when the Electoral Commission lawyer elected, to not want the witness to be in the box and said that they had also closed their case. What were people saying?
Well, I think the best response I can give to your question is to point you to what the Chief Justice said in adjourning the case. Chief Justice Enini Yeboah did indicate that they were not expecting this particular request, and so they are going to take an adjournment to have legal arguments on the issue, and then a decision will be rendered. That is the extent to which it came as a surprise to many of us in the courtroom. If the panel wasn't expecting it, how many of us could be expecting it? It is worth noting that indeed, in one of the press interactions that we had with Kojo Oponkroma, who is the chief spokesperson for President Akufo-Addo's legal team, he did indicate that when the petitioner closes his case, they will have to take a decision as to whether to call upon the court to proceed to deliver judgment or not. And so that gave us a sense of what could perhaps happen. But many didn't see a situation where the Electoral Commission, the body whose chairperson has been accused of changing figures and announcing results that were error-ridden, a lot of those who were present in court did not foresee a situation whereby they will not be allowing the EC chairperson who has filed a witness statement opposing the request that has been made, and the reliefs that seek to suggest that no one won the election, will now come to the conclusion that she does not intend to enter the witness box through her lawyers because her case has not been made. And so yes, it came as a surprise to many of those who came into the courtroom. And while the petitioners hold the view that it is to escape cross-examination, the respondents insist that the petitioners have simply not put across a case to merit a response to be provided.
Was it as equally surprising when Akoto Ampao also did indicate that they had also effectively closed their case and that McMahon would not be in the witness box?
It wasn't surprising to me in the sense that once the EC lawyer did indicate that they did not intend to do that. From what we have seen in the course of the proceedings, more often than not, in fact, there has not been a single occasion, except just today when one objection was raised, that you saw the EC and the lawyer for the second respondent being on opposing sides. They are always on the same sides in terms of the issues that happen. And so once the EC put in that request, I was expecting that the second respondent would toe the same line or also hold a similar view. And I mean, we know for a fact that they are independent lawyers representing different clients. But nonetheless, they tend to be on the same side of a lot of the issues that have come up. And so in that regard, I expected that to be the chart that follows. And it followed in that regard as well. When Akoto Ampao did indicate that Mr. Peter McMahon, who has filed a witness statement, they don't intend to have him go into the box and have the witness statement even adopted as evidence to be cross-examined by the lawyers for the petitioner and the first respondent if they are minded to do so.
The very last address from the Chief Justice was on granting interviews. And right afterwards, we saw Marietta come to address on behalf of the petitioner's legal team. Was there anything different from today's presentation? And we're comparing from previous ones.
Well, I think the first issue is, if you recall, the first time that warning was given, reference was made to lawyers who are counsels on record. In the second instance, when the Chief Justice was sounding that caution again, from my understanding, he was still referring to lawyers on record. But at a point, he now mentioned Marietta specifically to make reference to the fact that certain comments that have been made are not really the very best of it. And so that equally came as a surprise to us. We have a lawyer here. He's one of the spokespersons for Mr. Mahame's legal team, Edwiji Tamaklo. He joins us here quickly to clarify some of the issues for us. I mean, first, the latter part of the CJ, there was some directive about lawyers in the case speaking. We had thought that earlier the directive was referring to those who are not lawyers on record, but we saw a reference made to Marietta Briapia-Opon, who addressed us a short while ago. What was your understanding of the directive from the Chief Justice?
My understanding, with respect, is that we should not appear to give a comment that will be prejudicial. And the court was very clear on that. If our commentary amounts to more or less impugning maybe motive or anything into the court, we are not supposed to do that. That's my understanding. And as you are aware, right from the beginning, we decided that the lawyers that will be speaking will not be announced. That's what we decided. That once you be speaking, you will not be announced, so that you will not be on record as having been announced and still speaking. So you notice that reference to my senior Frank Davis and Yaopon had to do with the fact that they have been announced as lawyers on record. In that case, you cannot appear to be engaged in the media.
The other question that I put to your senior colleague, Marietta Briapia-Opon, was to the ordinary man, when you take a case to court and you lead evidence to support a certain conclusion and you are done, and the person that you are making certain claims against decides that I'm not going to lead any evidence, why should that not be good news? It's a question that I asked and she said they are worried. I didn't understand that response.
No, because you have an answer. The answer is still on record. If you are saying that your witness statement should not be relied on and you want the answer, because the answer contains factual averments. Those factual averments, as it stands, have they been proved? No. So if you are saying that your witness statement should not go in, then your answer to the petition ought to be struck out as well. It's also important to say that, you see, election petitions generally are sui generis. They come with its own unique character. And that is why you saw the struggle from the beginning. Ordinarily, in a proper High Court matter, where CI 47, because it's an original action, is regulating, the nature of the case management will not be done in this form. It would have been done differently. Also remember that as far as this one is concerned, there's also the need for speed. CI 47, among other, CI 99. CI 99, where does it have provision on the route we are going? There's nothing. And remember that this court has made it clear that they intend to comply strictly with CR 99. When we brought the interrogatories, you remember what happened? And the subsequent application, the court made it clear that they intend to comply with CI 99 strictly. And that is why Mr. T asks a simple question. Where in the rules are you premising your application? Yes, I've heard commentary like, oh, you cannot compel someone to come and testify. Why? What is the essence of a subpoena? Is it not to compel? That's the essence of a subpoena, to compel. So it cannot be the case that a witness cannot be compelled. There are processes in doing that. We believe that we've not even gotten to the point where you say you want to subpoena someone. That's it. And so the whole suggestion that, oh, you cannot compel someone to testify. There have been several instances where witnesses who were not willing have been compelled by our courts to come and testify. So I don't think this is a novelty.
Okay, thank you very much. You heard the Digital Maclo there. He's one of the spokesperson for Mr. Mohammed's legal team. I'm joined by Faisal Sise here. He's a private legal practitioner and also a member of the MPP's communication team. I mean, just a quick reaction from you. But first, the point is that there are some who say that should it not be in the interest of the ordinary people who are watching the court proceedings that all sides let their witnesses speak for them to understand, not the legal issues that you guys are raising that you are hiding behind, not to allow your witness take the stand?
You see, the court of public opinion, when it's not founded on strong legal basis, it remains what it is, okay? In every civilized and progressive society, you want the opinion that dominates to be one that is properly well grounded. You have a case where you've come to a court of law, you've made an application or you've brought a petition against a legal person like the Electoral Commission, a constitutionally mandated body which conducts election in this country, your allegations are that the declaration that the EC body made by declaring President Nana Dankwa Akufo-Addo as president-elect on the 9th, that no candidate obtained 50% plus one. That is what you are saying. The burden remains on you, the one saying, no matter how huge you are, for you to make the allegation and present your evidence to support same. If you fail to, you can't compel anybody. If I take you to the chief's palace and I make allegations against you and produce all the evidence, and you tell the chief that you don't have any evidence, it is there for the chief to look at it and say, okay, based on evidence I've received, I'm going to rule in favor of you or the other party. If they know they've made out their case, if they know the allegations they've put out, if they know the spin they've put on this matter since it started, that it has been well supported by the 3 witnesses that they've brought to court, they should be jubilating. But the fact that they are not jubilating means that they know that the allegations they made were unfounded. And if it's unfounded, then clearly what is in the public domain should go against them, but not the other way around. So they talk that, oh, it's a constitutionally mandated body, so in the public interest, or it's in the public interest for the EC to provide evidence, I think it's much ado about nothing. In 2013, when we came to court, we didn't just come to court. And I'm happy you've asked very intelligent questions since we've been holding the press conference, since this matter started. Everybody keep asking the same basic question. Where are your figures? Where are your pink sheets? It is the only basis upon which you can challenge the validity of an election. And that's what Article 64.1 says. The Article 64.1 does not say that if you have any doubt about your head how the EC conducted itself, come to the Supreme Court. No. It says come and challenge the validity of a presidential election. That is the threshold in the Constitution.
As far as you are concerned, they are not doing that.
Well, you can see from the disappointment and the anger, and now all of a sudden, why is she running away? If they have made out their case like we did in 2012, because in 2013, if we had not made our case, trust me, the ruling would have gone in our favor if the EC had decided not to mount the stand. So the EC had to mount the stand to give contrary evidence to show that they did their work creditably. But in this case, the EC says they don't want to come. Second, the respondent says we don't want to come. And you who have brought the case and provided 3 witnesses, including your general secretary, who virtually sat in the box, were given all the changing figure scenarios, each one of which he punched. He declared Nana Dankwa Akufo-Addo as the one who won. Each one of it. So clearly it means that they know that their case is moot. And interestingly, today we are hearing for the first time that one of the important persons who were in the EC room, who was there to protect their interests, apparently spent 3 hours in the EC's office. And what was he doing? He was offered tea. And his complaint was that there was no biscuit.
Thank you very much. Faisal Sise, he is a member of the MPP's communication team. He's a private legal practitioner as well. Mamavio Usabaji, this is what time will permit us, but this is the latest from the Supreme Court. The case returns tomorrow for legal arguments related to whether or not the respondents can opt not to call witnesses to take their stand to be cross-examined. My name is Joseph Akable.
Joseph Akable, our court correspondent. And it is a wrap from us. We thank you for following our election petition updates in association with Petrosol Clean Fuel in full quantity. It's always a delightful experience. DBS Roofing, we truly are your roof experts, and Coameksha, the immune booster for your general well-being. So the petitioner has closed his case. We will see the decision, or hear the decision of the court tomorrow in terms of how the arguments would go and whether or not we will not see witnesses from the respondents on the stand. But as we have heard, you cannot compel a witness to be in the box. What will the courts finally decide? Join us on Election Petition Update tomorrow from 9:30 a.m. My name is Mamavio Usabaji. Thanks for your company.